Mother, just very simply state what I think is the architecture of 370.
Yes.
Let's go back to it, Mother. Notwithstanding anything in this constitution, the provisions of Article 238 shall not apply in relation to Jammu and Kashmir. That's done away with now, Mother, because those are Part A, Part B, Part C, Part D states. Therefore, Mother, that's over. We're not part of any of those states. The power of Parliament. Now, here, Mother, it relates to the power of Parliament to make laws. Just kindly note that.
That's the ordinary lawmaking power.
Yes, the ordinary lawmaking power for the state shall be limited. Now, that's important. Even the lawmaking power is limited to those matters in the union list and the concurrent list. Your Lordships will see state list is out because residuary power is with the state, which in consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India as the matters with respect to which the Dominion legislature may make laws in that state. So that's that list, Manoj.
We saw the list in the morning.
The list in the morning. So it is only those that Parliament may make laws, but that also with consultation. And consultation is mentioned here itself. Doesn't have to be repeated in the proviso, it's mentioned here itself. Correct? That also has to be consultation. And just let's clarify the architecture. That's with consultation. Now you come to B. Such other matters, that is again power of Parliament to make laws. Such other matters in the said list. So, apart from the list that are in the instrument of accession, such other matters in the said list.
This list refers to union and concurrent list.
Yes. Only list 1 and 3.
1 and 3.
Well, as with the concurrence of the government. So now, Mullahs, that law has to be also with concurrence of the government. So we are dealing only with laws here. Lawmaking power. That's the first, Mullahs, limb of the argument.
That's the restriction on the lawmaking power.
That's the lawmaking power. Concurrence is mentioned here in respect of other matters, Mullahs. No proviso is required. Here, no proviso is required. Now, let's leave the explanation for the moment. The provisions of Article 1 and this article shall apply. See, the provisions of Article 1 and of this article shall apply in relation to that state. So, this is Article 1 and this Art 370. This becomes relevant for D, ultimately. Now come to D. D starts with the word. Now, D doesn't deal with laws. It deals with proclamation and orders of the President. Provisions, such of the other provisions of this. I pause here, Mothers. Others excluding 1 and 370. One second, hold on. Let my lords read it. So D is, C says the provisions of Article 1 and of this article shall apply in relation to that state. And D says such of the other provisions, that is excluding 1 and 370, shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify.
Just 1 minute. C cannot be read in isolation without reading sub clause 1. Notwithstanding anything contained in this constitution,
Correct.
The provisions of Article 1 and this article shall apply in relation to that state.
Correct.
So that means only that Article 1 and this article will apply only in relation to that.
That's all I'm saying, nothing more. Then read D.
Now D, if one reads D.
Such of the other provisions.
Correct.
Which means 1 and 370.
As well as other than the matters in the concurrent and the union list.
That's correct.
That also.
That also, I agree. And 238 also.
Just 1.
Reading of D
Yes.
Whether Khanna's reading is that it will include D, but C, but exclude A and B.
Cannot, Mullah.
It will. Otherwise, it will lead
Yeah.
to a situation you are saying that 370 is a permanent article.
Mullah, we'll come to that later whether it's
1 minute,
permanent.
yes, that's your argument.
Mullah, I
370 is
want-
a permanent article which cannot be undone by even with a concurrence.
Let me forget that, but I made that argument.
Right now, you're just giving us the structure of the article.
Forget that what I made that argument.
That you're
It
giving
is
us the structure.
temporary.
Yes.
It is temporary on 26th of January 1950. Let's forget about anything else. It is temporary. Why? Because, Malats, the Constituent Assembly may still choose to. So it's temporary. There's nothing wrong with that heading. Let me finish. Let me finish the architecture and then I'll come back. So, Malas, I was reading such of the other provisions of the Constitution. So that is other than 1 and 370 shall and 238 shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now you come to orders, not to laws. Provided that no such order. What order? Order under D. Colon. Read the colon, mother. Specify colon. Right? Provided that no such order which relates to the matter specified in the instrument of accession, again, mothers, of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of that state. Again, a colon. Provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence. You go to B1 and B2. So that was the law, the same template, now the orders for the rest of the provisions. Then read 2 mullahs. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision and may be taken thereon. Same template of B and D, Malak. And they can reject it. They need not confirm it. That's how you retain sovereignty, which is the instrument of accession. And if it don't retain it, it's temporary. That's why temporary. Well, I'm just trying to explain
With the structure of 370.
Yeah.
You complete clause 3,
Yeah.
then I have one question.
Sure,
But but we'll first, you can complete, otherwise I'll be breaking your link. It's on some unrelated area, therefore.
Notwithstanding anything in the foregoing provision. So, Malad, it's notwithstanding in the beginning of the article. Please note that. Notwithstanding anything in the foregoing provisions of this article, so notwithstanding in 370, the President may by public notification declare that the article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly shall be necessary before the President issues such a notification. So if the Constituent Assembly recommends it, namely, that we want to abrogate 370, then on that recommendation, the President will issue a notification. And this article is contained in subclause 3. Doesn't have to be in D. So that, according to me, is the architecture of 370.
Now, Mr. Sibyl, I have just one question on this. D1 refers to those matters in the instrument of accession which have been ceded by the Maharaja to the dominion's power. B2 refers to all other matters in the union and concurrent list other than what is covered by 1.
Fair enough.
Now, suppose in the area of the union and the concurrent list, something is not covered by B1 or by B2. In other words, it's not referable to those subjects mentioned in the instrument of accession, and it's not covered by B2 at all. That power is not entrusted to the state.
B2 is all other lists, Mullah.
No. B2 says such other matters in the said list as with the concurrence of the government, the president may order specific.
All matters in the list.
Right. Of course. It covers, it's a residuary.
Everything.
Yeah. So you have to take the concurrence of the state.
Yes.
Now, suppose it is not covered by B2 in the sense that there is no concurrence of the state. Right? It's not covered by B1.
Yes.
And you have not taken the concurrence of the state under B2.
Correct.
On such an aspect, the state legislature cannot exercise power because it's not in the state list. One second.
Nizam,
one second.
Residuary power of the
One
state.
second.
Yeah.
The state legislature, the state legislature is operating on the state list.
And residuary power, Mullah.
Residuary power came in and when? Under what?
Other way around, Mullah.
No,
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself.
Instrument of accession.
Yes, it is part of Mullah's all orders of the government.
No, but has specifically
it's also part of the constitution. I'll show
I
that.
just wanted to see whether it's part.
Yes. You're always to take it, Mullah.
Because otherwise there'll be a peculiar situation.
Yes.
Where neither parliament can exercise power, nor can the state legislature
I
exercise
take
power.
your lordship's point. I will demonstrate to your lordships that the residuary power was with the state legislature throughout and with the state government throughout. That was the condition on which, Mullah, the accession took place. And I will demonstrate that to your lordship. That's
Mr. Simple,
the least of my problems.
Mr. Simple, slightly different.
Okay. Yes. Yes.
Which is very different from what is subject matter of 1 and 2.
Yes, right.
Because they do not deal with abrogation of the
Absolutely.
article.
Absolutely. Right. Yes, absolutely. Your lordship is right.
And therefore, when we read at that power, which is specifically conferred on the president,
Yeah.
then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No,
For the time being, just leave the proviso.
I can't read the constitution in this fashion. I can't even read an act in that fashion. Let's forget the constitution. How do I leave the proviso when the constitution is staring us in the face?
No. The question was,
is putting to
therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct. But it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso is satisfied, that clause 3 will apply. Otherwise, if the conditions of the proviso are not satisfied, clause 3 will not apply.
That's how your lordships have interpreted proviso since 1950, Mullah. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a difference, Mullah. Yeah.
It depends upon the nature of the...
provisos are sometimes change colors.
Proviso, Mullah. Proviso that the recommendation...
Rule for a proviso in that sense.
Provided that the recommendation of the legislative of the Constituent Assembly shall be necessary. It's a restriction on the exercise of power. That's right. Referred to in clause 2, Mullah.
Quick way to interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state is no longer exists.
But kindly read 2, Mullah. If if the concurrence of the government of the state referred to in para 2, subclause B of 1 or the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause and clause D not applicable to clause C.
No,
Then
what
the
I'm
second
saying is,
proviso will not apply.
in both cases,
And therefore only subclause 3 will apply.
Himala's point is clause 2 says that
Clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of argument.
No, there is something that's missing, Malas. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malas? The purpose is given in clause 2. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
Right? That's your point. You get that point?
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body. The Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and thereafter it becomes functus officio, so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
This is the problem, Malaj, with the problem there is then you are applying 3 without the proviso and saying this is a blanket power, then Malaj, the president can do it anytime without any consultation.
Also, Mr. Sibal, one thing which we must
just passes an order.
Mr.
That
Sibal,
I integrate. That's
one thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary
Sure.
for a limited period of time,
Right.
but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
That it
Laws
comes to
made
an-
earlier.
Right. I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yeah.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372,
Right.
which continuance in force of
Existing laws.
existing laws,
Yes.
which then says, shall continue in force until altered or repealed or amended by a competent legislature
Right.
or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of part 21. And 370 specifically uses the expression temporary.
It had to, Malad. It had to.
So, can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the Constitution?
But that's one. Your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
But why did the Constitution then put it in part 21?
Because, Malad, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, part 21 does not deal only with Jammu and Kashmir. It deals with other states.
I'm sorry, I didn't get it.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it's a separate, independent provision and has to be interpreted on its own terms. You can't incorporate Malad's concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
The note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Malad. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else. Temporary, supposing, Malad, not that I should say so, because one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
There are two types of temporary provisions in part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we're just... When Mr.
Not till abrogated.
When we are putting your point, it's actually we are thinking.
I understand.
Yeah, we are just.
I understand, Malad. This is your lordships have always done this, Malad. Your lordship. This is a very fruitful debate because we all have to understand. Well, we are here standing.
And it's only in that
India.
process that
We're
we can
really. For
really.
the people of India, we're not. Malad. This is not something that we believe we are totally integrated into India. That's not an issue, Malad. We are. We have said so. Therefore, there is no. As far as. I mean, our constitution says we're an integral part of India. So where's the question of moving away from that? Yes, yes. Yes. Yeah. Yeah. There were only two choices, Marat. We said, the Constituency Assembly said all of constitutional to apply. We'd be like any other state.
But they don't have to make a constitution of their own.
Then they don't have to make a constitution of their own.
Indian constitution applies.
Once again, they don't have to make a constitution of their own. The Constituent Assembly would say, we integrate into India. We're part of India. We're like any other state. We don't need a constitution. And all those lists will apply. That power is there. So why was it called a temporary provision? Because that had to be decided by the Constituent Assembly. And then you interpret the terms to find out how that power is to be exercised. Because it was unlike any other state. The residuary power was always with the state. In the Delhi Agreement in 1952, I have a reached.
370 came in with the original constitution.
Yes.
But is there anything in the Constituent Assembly debates which throws
Yes.
lights on why they introduced it?
I'll do that straight away. Yes, I'll give your lordships that. Exactly what I'm saying is what they said.
Let us see the CAD.
Volume 8. Volume 8.
And hold on. Interpretation now.
This volume 8, huh? Yeah. Originally, I kindly see volume 8, PDF page 1173. It's okay, 1174 actually. Volume 8, PDF page 1174.
1174.
PDF 1174.
Volume
4034.
Running page 4035.
4035.
Yes, running page. But PDF 1174.
Volume 8.
Volume 8. By now we know your lordships elicit answers in order to find out what we wish to say. Not that your lordships have ever decided on one way or the other. You always do that, and I've seen
The
this
last
happening
word is
before.
said in a matter,
Yes,
Mr.
exactly.
Sibal, everything is open.
When the printed word comes, that's the last word.
Yes, I always said, Mr. Sibal, the judge is very quiet, there is a problem.
That's a real problem. It's a real problem, which we face
Actually, Mr.
occasionally.
Sibal, there are times when you start dictating a judgment, you start dictating it with a certain...
And then you change your mind.
And you start dictating with a certain conclusion in mind,
I see.
because that's what you have formed. When you start dictating it,
Yes, yes.
then you realize that your line of reasoning is wrong, because, when you dictate, the logical syntax has to fall in place when, you are engaged with yourself. Then you realize, no, it's not going to fit in like this.
Quite frankly, Milad, and I'll be honest, when I looked at it myself, I asked this question that your lordships is asking me. I answered myself that question.
4034, Mr.
Yes, 4035.
Oh, sorry, 1174.
Yes, 1174. Then kindly come to Milad, the sentence starting. Sir, this matter, your lordship has that? They set out Milad.
Gopal Swami Iyengar?
Yes, Iyengar, Gopal Swami Iyengar.
Yes.
Then it says, sir, this matter, the matter of this particular motion relates to Jammu and Kashmir. The House is fully aware of the fact that the state has acceded to the dominion of India. The history of this accession is also well known. The accession took place on 26th October 1947. Since then, the state had a checkered history. Conditions are yet not normal. The meaning of this accession is that at present the state is a unit of a federal state, namely the Dominion of India. This Dominion is getting transformed into a republic, which will be inaugurated on 26 January 1950. The Jammu and Kashmir state, therefore, has to become a unit of the new Republic of India. As the House is aware, accession to the Dominion always took place by means of an instrument which had to be signed by the ruler of the state and which had to be accepted by the Governor General of India. That has taken place in this case. As the House is also aware, instruments of accession are a thing of the past in the new constitution, will be a thing of the past in the new constitution. The states have been integrated with the Federal Republic in such manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the Republic, but they are mentioned in the constitution itself. And in the case of practically all states other than the state of Jammu and Kashmir, their constitutions also have been embodied in the constitution for the whole of India. And all those other states have agreed to integrate themselves in that way and accept the constitution provided. The discrimination is due to the special, why this discrimination? That's the question asked. The discrimination is due to the special conditions of Kashmir. That particular state is not yet ripe for this kind of integration. It is the hope of everybody here that in due course, even Jammu and Kashmir will become ripe for the same sort of integration as has taken place in the case of other states. At present, it is not possible to achieve that integration. There are various reasons why this is not possible. Now, I shall refer again to this a little later. In the case of other Indian states or unions of states, there are 2 or 3 points which have got to be remembered. They've all accepted the constitution framed for states in part 1 of the new constitution. And those provisions have been adapted so as to suit conditions of Indian states and union of states. Secondly, the center, that is the Republican Federal Center, will have power to make laws applying in every such state or union to all unions and concurrent subjects. Thirdly, a uniformity of relationship has been established between those states and unions and the center. Kashmir's conditions are, as I have said, special and require special treatment. I do not want to take much time in the House, but I shall briefly indicate the special conditions are. In the first place, there has been a war going on within the limits of Jammu and Kashmir. There was a ceasefire agreed to at the beginning of this year, and that ceasefire is still on, but the conditions in the state are still unusual and abnormal. They have not settled down. It is therefore necessary that the administration of the state should be geared to these unusual conditions until normal life is restored. Part of the state is still in the hands of rebels. We are entangled with the United Nations in regard to Jammu and Kashmir, and it is not possible to say now when we shall be free from this entanglement. That can take place only when Kashmir problem is satisfactorily settled. Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the Republic or wish to go out of it. We are also committed to ascertaining the will of the people by means of a plebiscite, provided that peaceful and normal conditions are restored, and the impartiality of the plebiscite. This is not relevant anymore.
Next sentence. Next sentence.
Next sentence, but this is not relevant. Plebiscite issue not relevant.
Part is not relevant as per your comment. Even the part before that.
Yes, now see further, brother. We have also agreed that the will of the people, through the instrument of a constituent assembly, will determine the constitution of the state as well as the sphere of union jurisdiction of the state. That's why it was a temporary provision. Now, next paragraph. At present, the legislature, which was known as the Praja Sabha in the state, is dead. Neither that legislature nor a constituent assembly can be convoked or can function until complete peace comes to prevail in the state. We've therefore to deal with the government of the state, which, as represented in its council of ministers, reflects the opinion of the largest political party in the state. Till a constituent assembly comes into being, only an interim arrangement is possible, which is why it is temporary, and not an arrangement which could at once be brought into line with the arrangement that exists in the case of other states. This tells your lordships why it is temporary. Now, if you remember the viewpoints that I have mentioned, it is inevitable conclusion that at the present moment we could establish only an interim system. Article 306A as, now what is 306A? 370. is an attempt to establish such a system. Interim till the Constituent Assembly decides. I shall now proceed, Madam, that's not relevant. So clearly, Madam, clearly, it gives you an indication why it was interim. It gives you an indication why it was temporary. Because there was nothing in place. Legislature was not working, Constituent Assembly was not in place, and the will of the people had to be taken, which was reflected in the Constituent Assembly. Therefore, it was temporary. And therefore, 370, now remember this, when 370 is enacted in 1950, at that point in time, nothing is in place. And yet in 373, they say, you will have to get the recommendation of the Constituent Assembly. That is, dehors the Constituent Assembly having been formed. Dehors its constitution. Why would the Constitution say that? Then kindly come to 4039. Second paragraph of 4039. Yes, that's. Now it's very interesting, Madam. Well, let's read the paragraph, then we come to clause 2. First that, and then I'll read the other paragraph. Then we come to clause 2. My lords have that? That's PDF 1178. 4039. That's right.
Justice called them.
No, Malas, actually,
Justice called them.
maybe Malas, I should start with volume 8, 1176. Let's take 1176. PDF 1176. Turning page 4037.
Read the whole thing.
Yeah, I'll read the whole thing.
Because it's the interpretation they asked you before lunch.
Malas, most of your lordship's questions, Malas, hopefully are answered in this. There's the second portion of this article, 1076, Malas.
He hasn't got it.
Yes. He says, Malas, I shall now proceed to, your lordship has that paragraph, I shall now proceed to take the House through the provisions of this article. That's 306A, which is 370. As honorable members will remember, the Constitution of Indian States is mainly governed by Article 211A of this Constitution, which applies to the Constitution to Indian States, the Constitution of Indian States, subject to the modifications contained in Part 6A, read with the schedule. So far as that provision is concerned, I've already indicated to you that the provisions regarding the Constitution of other states could not at present be applied to Jammu and Kashmir. Therefore, Clause 1 of A of this article says that the provisions of 211A of this Constitution shall not apply to the state of Jammu and Kashmir. That's 238, Malas. 211A is 238A.
Now B.
The second portion of this article relates to the legislative authority of Parliament. So, Parliament may by law. That's B. Over the state of Jammu and Kashmir. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to the three subjects of defense, foreign affairs, and communications. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they include, they number some 20 to 25. Now, these items have undergone a change in description, in numbering, in arrangement, as amongst themselves in List 1 and List 3 of the new Constitution. It is therefore necessary that the items mentioned in the instrument of accession should be brought in line with the changed designations of entries in the lists 1 and 3 of the new Constitution. So, Clause 1B of 306A says that this listing of items as per the terms of the new constitution should be done by the president in consultation with the government of the state. That explains, Manoj. B1. Clause B2 refers to possible additions to the list in the instrument of accession. And these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition in the government of the state that is provided for. Then there is the explanation, which defines what the government of the state means. The government of the state is defined both in the constitution, which is now supposed to be in the force in Jammu and Kashmir, the state, as well as the proclamation with the Maharaja issued on 5th March 1948, the terms of which are as follows. Then kindly come to C and D. Yes, second last paragraph in 1177, PDF 1177. 4038. My lord has that. Clause C and D refer to the provisions of the Constitution other than matters listed in 1 and 3. These various provisions have been divided into certain categories. The first, according to this draft, is that Article 1 of the Constitution will automatically apply. As you know, it describes the territory of India and includes among those territories all the states mentioned in Part 3, and Jammu and Kashmir is one of the states mentioned in Part 3. With regard to the other provisions in the Constitution, these will apply to the Jammu and Kashmir state with such exceptions and modifications as may be decided on when the President issues an order to that effect. The order can be issued...
Just read the sentence once again. With regard to other provisions of the Constitution,
Yes,
these will apply when the President issues an order to that effect.
yes,
That order can be issued with regard to subjects mentioned in the instruments of accession only after consultation with the government of the
Yes.
state.
yes.
With
Correct.
regard to other matters, concurrence of the government has to be taken.
That's B1 and B2, Madam.
Two provisos.
Two provisos, B1 and B2. That order can be issued in regard to subjects mentioned in the instrument only after consultation. In regard to the others, it concurs. Now, it is not the case, nor is it the contention of the members of Kashmir government, whom I took opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the...
The case, no.
Sorry.
Two provisos.
That's right. Now, it is not the case, nor is it the intention of the members of the Kashmir government, whom I took the opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the Constitution are not to apply. That particular point of view is that these provisions would apply only in cases where they can suitably apply and only subject to such modifications or exceptions as the particular conditions of Jammu and Kashmir may require. I wish to say that no more about that particular point at the present moment. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir state. Now, these relate particularly to matters not mentioned in the instrument of accession. And it is one of our commitments to the people and government of Kashmir that no such additions should be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination by the Constituent Assembly of the state. This is commitment. Now you will recall that in some of the clauses of this article, we have provided for concurrence of the government of the state. The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. What can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to clause 2, not with reference to clause 3.
Yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm saying, I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir, but that cannot be a permanent feature of the Constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. Well, there can be nothing clearer than this. I mean, we in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. Next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India, will be a unit of the future Federal Republic of India, and the Union legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later addition with the concurrence of the government of the state, and steps have to be taken for the purpose of convening a Constituent Assembly in due course, which will go into the matters I have already referred to. When it comes to a decision on the different matters, it will make a recommendation to the President, who will either abrogate 306A or direct that it shall apply with such modifications and exceptions that the Constituent Assembly may recommend. That, sir, is briefly a description of the effect of this article, and I hope the House will carry it. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our Constitution that it will be constituted. And the ultimate authority of abrogating 370 will be left to the Constituent Assembly. And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass an order. Absent that, it can't be done. That was the understanding of the lawmakers, of the constitution makers of India, of the Constituent Assembly. That is why it was put in. It was not a temporary provision in the sense that it had ultimately 370 had to be abrogated. That's not the meaning of the temporary provision that we're talking about. In any case, Malaz, a heading of an article can determine the content of the article. Content of the article is clear. So, Malads, the government of the day was staring at the provisions of Article 370. And according to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said it was tossed out of the window through a political act, not through a constitutional act. Such a political act cannot be determined by the Parliament of India. It's not in the remit of the Parliament of India to take a political decision to abrogate 370. And I will demonstrate as we move along, Willard, how it was done and in what manner it was done. Nobody can deny that the people of Jammu and Kashmir are with the Union. It's an integral part. Nobody can deny that. But there is a special relationship. There is a unique relationship which is engrafted in 370 itself. You can't jettison that except by following a process which is ordained by law. So, as your lordships asked me on the constitution, I wanted to just mention this. This is the debate. Amarat.